In our last video, we broke down the Law Commission's proposal on criminal appeals, highlighting key recommendations, pinpointing concerns, and questioning whether real reform is on the horizon. While we welcomed changes like extending appeal deadlines and allowing the Court of Appeal to appoint its own experts, we couldn't ignore the gaps. What about fresh evidence? What about cases where doubt lingers despite new argument or evidence is missing? The Law Commission's decision to leave these areas untouched raises a crucial question. Are we missing a critical opportunity to strengthen safeguards in our justice system? Today we go further. What happens when appeal rights fail? When the system doesn't just falter but breaks down entirely? That's where the Criminal Cases Review Commission, or CCRC, comes in. In this episode, we will dive into the Law Commission's proposed changes to the CCRC, exploring whether they truly address the deep flaws in the appeals process. Initially, we planned to cover both the CCRC and the compensation scheme in one video, but these topics demand the attention they deserve, so we have made the decision to tackle compensation separately. Today, our focus is razor sharp: the CCRC and the challenges of post-conviction justice. But beyond the legal mechanisms, we ask the bigger question: if these changes take effect, will they finally remove the roadblocks to justice? Will they be enough for those who have spent years, sometimes decades, fighting to clear their names? Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Before we embark on another exciting journey together, don't forget to hit that subscribe button if you haven't already. We are on a mission to reach 1,000 subscribers by spring. Can we make it? With your support, we can. Let's do this together. Now, let's dive in like true analysts, fearless and sharp. As always, we'll start with the basics and build from there. Let's get to it, bearing in mind our focus on convictions on indictment. One of the specific terms of reference of the Law Commission's review is to assess whether the conditions for referring cases to the Court of Appeal under the Criminal Appeal Act 1995 enable the CCRC to effectively carry out its role. In order to do so, we need to look, as the Law Commission did, at how the system works today. But just before we do so, we thought it important to highlight a point that the Law Commission felt important highlighting. That is that many responses to the previous consultation paper have raised concerns about the CCRC's culture, management structure, and leadership. While they acknowledge these criticisms and confirm that they have been considered, they state clearly that they are unable to put forward provisional proposals on these issues. The Law Commission then goes on in their consultation paper into some details as to the background and the various factors which gave rise to the creation of the CCRC, as well as the recommendations made by the Ransman Commission. We have discussed this in several of our videos, so we will not cover these here. I have created a timeline and a flowchart, which I will link in the description below, should you wish to look into this in more detail. So let's look at the position of the CCRC's referrals as it stands today. First, what kinds of cases can the CCRC refer? These include convictions and sentences on indictments from trials in the Crown Court, except for sentences fixed by law, convictions and sentences from summary proceedings in the Magistrates' Court, special verdicts such as not guilty by reason of insanity, as well as disability findings related to acts or omissions, and military cases, convictions from the court-martial and the service civilian court, focusing on sentences and convictions, leaving findings, verdicts and military cases aside. Where do these cases get referred to by the CCRC? So convictions and sentences from the Crown Court are referred to the Court of Appeal Criminal Division, and these are referred only on specific legal grounds, whilst summary convictions and sentences from the Magistrates' Court are referred to the Crown Court, where they are heard by way of rehearing. A key point: there are no time limits for applying to the CCRC or for the CCRC to make a referral. How is the decision made in practice? The CCRC's decision to refer a case must be made by at least 3 commissioners and do not require leave from the appellate court. Once a case is referred, the CCRC's involvement ends. From that point on, it is treated as an appeal by the appellant. However, the appeal must proceed based on the grounds set out in the CCRC's referral. If the appellant wishes to introduce additional grounds, they must first obtain leave from the appellate court. Note also that the CCRC has investigatory powers, such as powers to obtain documents or appoint investigating officers to assist with the investigation of a case. Now, let's look at the conditions for making a reference. These can be found in Section 13 of the Criminal Appeal Act 1995. The CCRC can only make a referral if it considers that there is a real possibility the conviction, sentence, verdict or finding will not be upheld because of, in the case of a conviction, verdict or finding, an argument or evidence not raised in the original proceedings or in any appeal or application for leave to appeal against it, or in the case of a sentence, an argument on a point of law or information not raised in the original proceedings or in any appeal or application for leave to appeal against it. And an appeal against the conviction, verdict, finding or sentence has been determined or leave to appeal against it has been refused. What does this mean in practical terms? It means that the CCRC can only refer a case for appeal if 2 key conditions are met. There must be new evidence or arguments. The CCRC must believe that there is a real possibility that the conviction, sentence, verdict or finding would be overturned because of something not previously raised in the original trial or any previous appeal or application for appeal. For convictions, verdicts or findings, this means fresh evidence or a new legal argument that wasn't considered before. For sentences, this means a new legal argument or previously unknown information that could change the outcome. And the second point is that all previous routes must have been exhausted. The case must have been already through the appeals process, meaning either an appeal has been heard and decided, or leave, permission to appeal, has been refused. Essentially, this ensures that the CCRC is only stepping in as a last resort when all standard appeal options have been used and there is a legitimate new basis for reconsideration of the case. However, Section 13 states that nothing in subsection 1b, I, or c shall prevent the making of a reference if it appears to the Commission that there are exceptional circumstances which justify making it. Exceptional circumstances which may justify the referral without a new argument or without a prior appeal include a guilty plea in the magistrate's court, for which there is no appeal route, the applicant's vulnerability, or the need for investigatory powers. However, a legal advice which states that there are no grounds of appeal or the inability to secure legal representations are not considered exceptional circumstances. Aside those cases, if there are no exceptional circumstances and the applicant has not used his right to appeal, the CCRC will advise the applicant to first make an out-of-time application for appeal to the Court of Appeal, and if this is refused, then the CCRC will be able to consider the application. A key point to remember is that the CCRC has discretion when deciding whether to refer a case. This means that even if all legal requirements are met, they are not obliged to make a referral. This discretion must align with public law principles, and the CCRC carefully weighs several factors including public interest, the seriousness and age of the conviction, and the overall benefits of making a referral. Although there is no direct right of appeal against a CCRC decision not to refer a case, this can be challenged through judicial review in the High Court. However, the High Court won't second-guess whether the CCRC made the right call on the real possibility test or other legal criteria. That will mean stepping into the CCRC role. Instead, the court will only step in if the CCRC's decision shows serious legal or procedural flaws, meaning its reasoning is so defective that it justifies intervention by another court. A High Court decision can be appealed, but this will not go to the Court of Appeal Criminal Division, but is heard by the Court of Appeal Civil Division. If an application is unsuccessful, the applicant is not out of option. They can submit their case to the CCRC as there is no limit on the number of applications allowed. However, for the CCRC to launch a fresh investigation, the new application must bring something significant to the table, new evidence or important details that weren't included in the previous submission. The term real possibility isn't explicitly defined in the Criminal Appeal Act 1995, but case law provides guidance. In a case known as Pearson, Lord Bingham explained that it means more than a remote chance, but less than a certainty, essentially a reasonable prospect that an appeal would succeed. To assess this, the CCRC examines past appellate decisions to predict how the Court of Appeal might respond in a similar case. It uses casework guidance notes and analyzes previous court rulings to refine its approach. However, this predictive test is challenging, as judicial decisions can be unpredictable, especially in borderline cases. Though issues with the real possibility test were raised as early as 1999, it was the Westminster Commission in 2021 which finally concluded that the real possibility test is problematic, and which led to the Law Commission being tasked in looking into an alternative test. The Westminster Commission's 2021 report, which we looked at in our last video, criticised the real possibility test, calling it problematic due to the subtle distinction between a real possibility and a probability, as it was noted in the case of Pearson by Lord Bingham. The Commission argued that the test makes the CCRC overly cautious. This is the Westminster Commission, overly cautious, leading it to anticipate the Court of Appeal's response rather than independently assessing potential miscarriages of justice. However, the CCRC disagreed, asserting that the test does not limit its ability to refer cases or compromise its independence. Reviews by the Ministry of Justice and the House of Commons Justice Committee found mixed opinions on the test's effectiveness. Critics felt that the Court of Appeal's restrictive approach hinders the CCRC referrals in cases of lurking doubt. We discussed this in our previous video last week. Lurking doubt cases are cases where, despite there being no specific legal error, the judges have an inherent sense that the conviction might be unsafe. However, the Ministry of Justice saw no strong evidence to change the test, emphasising that the appellate court remains the final judge of conviction safety and that the CCRC can still refer cases in exceptional circumstances. Despite this, the Justice Committee acknowledged widespread concerns that something about the test or its application is not working as it should. Instead of reviewing every single response from consultees, we will highlight a few to give a sense of the types of criticism directed at the real possibility tests. Some argued that the predictive nature of the test is overly cautious, contributing to low referral rates of about 3%. This approach, they claim, not only may result in deserving cases not being referred, but also stifles legal developments, as untested arguments are overlooked, leading to missed opportunities for legal innovation. Others criticized the requirement for new evidence, which they say makes it harder for applicants who need investigative assistance. Some also feel that the CCRC tends to look for reasons to reject cases rather than referring them, focusing more on rejections than on thorough investigations. There was also criticism that the relationship between the CCRC and the Court of Appeal is misaligned. While the Court of Appeal only requires the ground of appeal to be arguable in order to grant leave, the CCRC must apply the much stricter test of the real possibility test. And finally, Mr. Helly KC criticised the misapplication of the test altogether, particularly in the Malkinson's case, where the CCRC overlooked and misjudged the importance of key DNA evidence. The Law Commission conclusion was that the criticism that the CCRC's approach to assessing the real possibility test goes beyond the standard set in person is valid. The low referral rate suggests that the CCRC may be applying a higher threshold, essentially requiring it to be more likely than not that the Court of Appeal will quash the conviction. While the Law Commission agreed that the CCRC will refer a case when they believe a miscarriage of justice has occurred, they also acknowledged that the real possibility test appears to narrow investigations, focusing only on lines of inquiry likely to persuade the Court of Appeal. This approach, evidenced by the Henley Review, may have contributed to significant delays in Andrew Markinson's exoneration. The Law Commission concluded that the test is indeed hindering justice, as similar reasoning errors have been identified in other cases that the CCRC may be reluctant to explore speculative tests that could suggest a conviction is unsafe. Furthermore, they found that the CCRC's focus on predicting the Court of Appeal's actions may be based on a fear of upsetting the court by referring cases the court feels should not be. They suggest that while the CCRC shouldn't refer weak cases, further investigation should be encouraged if it strengthens the case for referral. The key concern, the Law Commission says, is whether the real possibility test is the right one. Their proposal, therefore, which can be found at question 55, is that the predictive real possibility test applied by the Criminal Cases Review Commission for referring a conviction should be replaced with a non-predictive test. Do consultees agree? This proposal, of course, is very much welcomed by us, and we do not need to explain the reasons, as most of our past videos speak for themselves. The Law Commission then goes on to consider the consequences of changing the test with a non-predictive test and whether this would open the floodgates, with sadly 25,000 applications previously rejected now needed to be considered, given that anyone can apply to the CCRC and each time the CCRC would have to apply the new test. The Law Commission concluded that given the CCRC has a discretion to refer and already a policy in place on how to deal with reapplication, it will be open to the CCRC to develop an internal policy for deciding whether to reconsider an application when it has already considered it under the real possibility test and rejected it. We envisaged that there will be a limited number of cases which would merit a reference under a new non-predictive test, and it will be open to the CCRC to decide which cases it thinks merit reconsideration. As per alternative tests, the suggestions went from there is an arguable ground of appeal, that the conviction may be unsafe, that it is in the interest of justice to do so. The Law Commission is of the view that any alternative test must be broader than the one used by the Court of Appeal, as otherwise some cases which might be quashed by the court would be unable to be corrected because they would fall at the reference stage. We agree with this reasoning, and that therefore the decision must be linking the test applied by the Court of Appeal with the test applied by the CCRC. As we mentioned in our last week videos, the Law Commission proposed the test for the Court of Appeal to remain that of safety. The Law Commission proposal is in question 56, where it states, we provisionally propose that the Criminal Cases Review Commission should refer a case to the appellate court when it considers that a conviction may be unsafe, where unsafe would encompass cases where the applicant is or might be not guilty, the applicant did not receive a fair trial, or the prosecution amounted to an affront to justice. Nonetheless, there is a general invitation by the Law Commission for consultees' views on any alternative, non-predictive referral tests. We, on our part, believe that the test must be much broader than that used by the Court of Appeal, and we agree with the Law Commission that it should not involve the interest of justice given the non-judicial nature of the CCRC. If the Court of Appeal test is that the conviction is unsafe, then we believe that a more appropriate test will be one of doubt, which we have coined as the real and unresolved doubt test. A case should be referred to the Court of Appeal, in our view, if after a full review of the evidence and trial process, a real and unresolved doubt remains about the safety of the conviction, even in the absence of fresh evidence or new legal argument. These tests would apply where, despite no new evidence or legal development, an objective and impartial review of the case reveals a deep concern that the conviction may be unsafe. This is distinct from speculative doubts. It requires a substantial and rational basis for concern based on an examination of the whole case. Instead of focusing only on newly discovered flaws, the test allows for holistic review, considering the quality and reliability of the prosecution's case, the conduct of the trial, including potential bias, ineffective representation, or unfair judicial directions, the overall strength of the conviction, even if it met the legal burden of proof at trial. Examples could be a case where the prosecution's key witness was unreliable or had a motive to lie, but no fresh evidence has emerged, or a conviction that depended heavily on circumstantial evidence, leaving major gaps in the case. Or cases where trial fairness is in doubt, for example, where a defendant convicted after poor legal representation, inadequate jury directions, but no new legal argument is available. A trial that may have been affected by implicit bias, even though this was not legally challenged at the time. And would also include historical convictions that do not hold up to modern scrutiny. A case that was accepted as sound at the time, but when viewed with contemporary knowledge, for example, about forensic reliability, coercive interrogations, etc., raises significant doubt. These tests, in our view, allows the CCRC to act where a conviction appears unsafe in substance, even if it remains formally sound in law. And what do you think? Let me know in the comments below. For completeness, we will now briefly highlight other issues examined by the Commission in Chapter 11. We will touch on them in passing, simply pointing out where they can be found. So the Law Commission provisionally proposes that the CCRC test for referring sentences as opposed to convictions should remain unchanged. That is, that there is a real possibility that the appellate court will not uphold the sentence. That is in question 57. We welcome the Law Commission's provisional proposal that the requirement that there must have been a first appeal or an unsuccessful application for leave to appeal before the CCRC can refer a case should not apply to appeals against convictions in trials on indictment, as per question 59. And of course, it goes without saying, given our proposed test for referral, that we also welcome the proposal that whatever test replaces the real possibility test should not be subject to a requirement for fresh evidence or argument. That is in question 60 of the consultation paper. As per the issue whether the CCRC should retain its discretion not to refer a case, the Law Commission proposes that it should, and that is at question 61. Question 64 deals with whether or not there should be a reform to enable the CCRC to explain publicly a decision not to refer a case. We particularly agree with Dr. Hannah Quirk that publication could offer a useful resource to researchers interested in the area and to make the process more transparent and allow for trends in the CCRC's decision making to be observed. And so we welcome the idea of the CCRC to be allowed to publish statements of reasons appropriately redacted in sensitive cases. That is at question 64. Another issue that the Law Commission considered was the independence of the CCRC from the Court of Appeal, with particular concerns about judicial influence over the CCRC's discretion to refer cases. In short, the Law Commission acknowledges that the effort of some judges signalling that certain types of referrals are unlikely to succeed, thereby discouraging the CCRC from referring cases, is not only improper but unconstitutional, given that the CCRC's discretion was granted by Parliament. Though they accept this may have influenced the CCRC discretion, it also recognises that no recent attempts have been recorded. Sadly, there are many other issues such as the CCRC's accountability and challenges to the CCRC's decision that we will not be able to cover in this video. These are all included in chapter 11, and we recommend you to take a look at them and let us know whether there is any specific issue you wish us to cover in future videos. As we wrap up this video, the key takeaway is that we are encouraged by the fact that the Law Commission has taken the review of criminal appeals extremely seriously. We believe that they have highlighted the real issues that are currently impeding the CCRC from effectively fulfilling its role. This is a significant step forward, but we are far from being able to definitely say whether the proposed changes will truly eliminate the roadblocks to justice. The success of meaningful change will largely depend on cultural shifts within the primary appeal bodies. That's the Court of Appeal and the CCRC. These shifts cannot simply be achieved through minor tweaks or even extended legal reforms. They will require a deeper transformation in how the system operates at its core. That said, the proposal we have analysed so far do represent a step in the right direction, and for that we are cautiously optimistic. But here is the major question mark. The Law Commission can only provide recommendations and for them to become law, they must be implemented by the government through Parliament. This process is slow and unfortunately not guaranteed. In their 2023-2024 annual report, the Law Commission provided some revealing statistics from its inception in 1965 through to the 31st of March 2024. From what we can see, about 63% of their recommendations have been implemented. However, of those implemented, it's crucial to note that many were only partially implemented, and there is no clear breakdown between those partially and those wholly implemented. Given the concerns we raised about the Law Commission current proposals on criminal appeals, particularly regarding issues such as fresh evidence in the Court of Appeal, where the Law Commission has proposed no changes at all, the reality of partial implementation could be even more problematic than it seems. These gaps could leave critical barriers to justice unresolved, meaning that those in need of reform may continue to face the same obstacles. I'd love to hear your thoughts on this matter and invite you to leave your comments below. This is a topic we will definitely revisit from multiple angles in future. So please continue supporting us in breaking down complex issues like this into understandable, digestible content. Together, we can push for the concrete reforms needed to ensure the system serves people, not just rules. Join us again as we sit and rise in this unique trial.